format. First, we will discuss Book 5, which is Labor Relations Law in the private sector. Afterward, too, we will discuss Executive Order number 180, which is Labor Management Relations in the public sector. After that, the last part of the assignment will be discussing the law on termination of employment, which is Book 6 of the Labor Code. I will try to go for a second round, if possible. And finally, we will end up by trying to engage in problem-solving solutions, meaning since we would have finished discussing black letter law, and we have finished discussing jurisprudential rules, then I'll try to end up, if possible, time permitting, problem-solving, item by item covered by the field assigned to me, labor relations. So there's a problem on Wednesday. Wednesday next week, I understand that Dean is calling a meeting of all bar reviewers. That was originally scheduled last week. Nevertheless, I could not also attend because I had classes. If I have to attend, I said if I have to attend, then I will ask you that we forego our break if possible, so that I can dismiss you on Wednesday at 10 o'clock. Apparently, the meeting will be in Rojas Boulevard, which is a far, far drive from here. I'll try to excuse myself if I can, but if not, we would have to do some solutions. All right. At the risk of being repetitious like an old broken record, I have to overemphasize that anything you read in Book 5, you have to begin with the constitutional foundation. For the very simple reason that anything you read in Book 5 is an implementation of what is provided for in the Constitution. But to begin with, to give you a complete overview of the Labor Code, where possibly the questions can come from, you have to begin with what the Constitution provides. First of all, Article 3 of the Constitution, and also on the policy declarations, lays down a very basic rule. The basic rule is the recognition by the state that labor is a primary social and economic force. Recognizing that labor is a primary social and economic force, the next sentence assumes importance because it now says, the state shall uphold, the state shall promote and protect the rights of workers and their benefits. Recognizing, therefore, the importance of the sector in society, there is now a mandate that the state must protect and promote their welfare. That is the basis of labor law and social legislation. But if you want to go to the details are first found in the Bill of Rights. All persons shall have the right to form associations, including labor unions, in both the public and the private sector for purposes not contrary to law. You will know the first right to recognize is the right of self-organization in both the public and the private sector. And you will know that as you read that provision, the word union is included in that provision. And the word union is modified in both the public and the private sector, meaning therefore unions for employees in the private sector, unions for employees in the public sector, and the word union is actually in the Constitution. It is limited only by the statement for purposes not contrary to law. From there, you move to Article 13, Section 3 of the Constitution. And you will note that Article 13, Section 3 of the Constitution begins with the statement, the state shall afford full protection to labor. When you relate that provision of the Constitution with the statement that the state is mandated to protect and promote the welfare and benefits of the worker, you will see that it is a complete picture. The picture is complete because Article 13, Section 3 now says full protection to labor. And the meaning of the word full is local or overseas, organized or unorganized. But as you go down Article 13, there is one particular area where there is an absolute necessity on your part to at least know it by heart, and that is, there are rights guaranteed in the Constitution that pertain to labor relations law. First, the right of self-organization. And you will note, the right of self-organization is an echo of what you read in the Bill of Rights, because the Bill of Rights said the right to form unions. Two, the right to bargain collectively. The right to bargain collectively is the second right mentioned. And thirdly, the right to engage in peaceful, concerted activities, including the right to strike in accordance with law. Going down further, now you will find a second policy statement, and that is, the state favors voluntary modes of dispute settlement. Thirdly, there is the question of shared responsibility and mutual compliance of the obligation. And lastly, sharing the fruits of production. For both two factors, the employer and the worker. If you put those provisions of the law on the left-hand side of your notes, and then you open the labor code, beginning with Article 211 until the end of Book 5, you will see that what you find in the Constitution is an implementation of what you find in the Constitution. Why is it important to you? It is important to you simply because when you answer the problems in the bar examination, be it a definition, be it an enumeration, be it a problem, you will have inevitably to go back to statutory law. And the statutory law is Book 5. But the statutory law is based on the Constitution. So you will see that the connection is absolutely necessary for you to understand, so you get a big picture of what you are about to undertake on the Saturday afternoon, or the Sunday afternoon, or the first Sunday of the bar examination. Now, having said that, it is time for you now to cut little by little, segment by segment, the provisions of the Labor Code and do it systematically. And you will note that you can reduce the provisions of the Labor Code Book 5 to 9 or 10 major areas of concern where the question can come from. First, the right of self-organization. Second, labor organizations. Thirdly, the appropriate bargaining unit. Fourth, certification elections, consent elections, and runoff elections. Fifth, collective bargaining. Six, unfair labor practice. Seven, strikes, lockouts. Nine, the labor injunction. And 10, arbitration of labor disputes. It is those 10 particular areas in Book 5 which carries the heaviest weight in the bar examination statistically, if you look at the number of questions asked. So we go to the first part. The first major area of concern of the law is the right of self-organization. What does it actually mean? If you look at the meaning of the right of self-organization, which is mentioned in the Bill of Rights as a right, and in Article 13, Section 3 of the Constitution, you will notice that it simply means the right of a worker to join, form, or assist labor organizations of their own choosing. Constitutionally wise, it is a reiteration of the two provisions. But the law goes further. The law goes further because a reading of Articles 243, 244, and 245 of the Labor Code is the implementing statutory rule on the right, which means then, using your background, the constitutional provisions, you now go to Article 243. You will notice that a reading of Article 243 tells you several things. First, the right of self-organization is extended by law to all employees. And you will note that Article 243 says, employees' self-organization for purposes of collective bargaining. But the end of the same article says, self-organization of employees for purposes of mutual aid and protection. You know now carefully that the purpose mentioned in Article 243, Group 1 employees, right, to self-organization for purposes of collective bargaining. Second group of employees, right of self-organization for purpose of mutual aid and protection. The distinction between the two assumes importance when it occurs, where there is a denial by law specifically of the right of self-organization for purposes of collective bargaining. The denial cannot extend to denying the worker the right for self-organization for mutual aid and protection. It is a constitutionally guaranteed right. Second, if you were to cut down Article 243 further, you will notice that the right extended by law is extended no matter what the purpose of the organization is. Whether the organization is profit-oriented or non-profit oriented, it is totally irrelevant because the right to self-organization is not based on the fact that the establishment is a profit-making institution. And then there is an enumeration. Schools, hospitals, educational institutions. You will note, therefore, that Article 243 is a broad statement of the rule. Now, you will note that under Article 244, government employees are likewise allowed to form unions. And if you go back to Article 3 of the Constitution, you will find that it says, in both the public and the private sector, and the public sector is Executive Order number 186. And finally, you have Article 2, 4, 5, which says supervisors have the right to form unions provided the unions are exclusively of supervisor. If you put the two together, then the constitutional guarantee, the statutory guarantee, the Supreme Court interpreted it as follows. 1. The right of self-organization is guaranteed twice. It is guaranteed by the Constitution, hence the statement, the right to self-organization is a constitutionally guaranteed right. It is likewise guaranteed by statute. Black letter law, Articles 243, 244, and 245, which then says that it is a statutory guaranteed right. When you fuse or put the two together in one sentence, judicial doctrine says, 1. The right of self-organization is both guaranteed A, by the Constitution, and B, by statute. And going further, the second judicial doctrine says, the right of self-organization is not a derivative right. It is a specifically ordained right. Specifically ordained because in clear black letter statement, the right is recognized. It is not derived from any other provision of the law. It is specifically ordained. And thirdly, the right of self-organization is a right of paramount value. It's a right of paramount value that cannot be denied on nebulous grounds. So you give a complete picture. To complete the picture then, you have Article 246, non-abridgment of the right of self-organization. And if the right is violated, you have Articles 248 and 249 on the unfair labor practice provision of the law. At this point in time, do you have any question on the basis of the right? That is the first brick in your foundation. It is the first brick in your edifice. The Constitution and the statutory guaranteed right. Do you have any question? You have right to ask questions. After all, any doubt is the beginning of wisdom. And you are here to review. I am here to guide you as best as I can. But my job is to make sure that it is clearly understood. So if you have any question, feel free to ask. Your classmates, for all you know, may also be doubting, but never had the courage to ask. All right, do you have any questions? So, given the right then, what is the qualification of a worker? A reading of Article 277C of the Constitution tells you that every worker on the first day of employment, regardless of whether the worker is regular or otherwise, the worker qualifies for union membership. In other words, that is the qualification set by law, that the worker on the first day of employment, regardless of tenure, regular, casual, probationary, seasonal, or project, is qualified for membership on day one. Now, there is a provision in the labor code that membership in the Communist Party or any party that advocates the violent overthrow of the government of the Philippines, that portion, I think, has been repealed with the repeal of the anti-subversive law. So So now you have your second foundation. Every worker is qualified. However, thirdly, if the worker is qualified, what is the extent and scope of the right? Now, here you have to be very careful. If you read Article 243, 244, 245, and 246, which is the non-abridgment clause, you will note that the law is couched in very positive terms. Positive because it says to join, to form, to assist labor organizations of their own choosing. In other words, three little words: the right to form, the right to join, the right to assist in the formation and organization of a labor union. TO is couched in very positive terms. However, you have the case of Reyes versus Trajano, Victoriano versus Elizalde. And you will know that in these two cases, the law recognized what is known as the negative statement of the right. The negative statement of the right means the worker is free to join, meaning he is also free not to join. The right is also to form, but he also has the right not to form. And lastly, the right is to assist. Also, the worker has no obligation to assist. In other words, while the law is couched in very positive terms, judicial doctrine recognizes that there's a negative statement of the right. And that negative statement of the right is the recognition that the law recognizes on the basis of one word: freedom. Freedom means free to do anything they wish to do so. Meaning, therefore, if freedom is an integral part of the right, the law now says the law will not compel a worker to exercise the right, because freedom means your own choice. However, you must note very carefully that under Article 248 of the Labor Code, which allows a union and an employer to negotiate and agree in a collective bargaining agreement, a union security clause. A union security clause is defined as an arrangement or an agreement between the employer and the union that membership in the union is a condition for employment, a condition for continuing employment, and if union membership is lost, there is a ground to terminate. If there is a union security provision, to that extent, the freedom of choice of the worker is negated. But the court said it is a policy consideration of the law that under Article 211, a strong and united labor movement is a policy statement of the law. In order to implement that policy statement, union security provisions are allowed under law. And when they are allowed under law and implemented, except for procedural and substantive due process, the courts will recognize the policy statement. So you have seen a complete picture. At this point, do you have any question on the relationship between the positive recognition of the right and the negative recognition of the right? It must be clear in your mind, including the correlation between the recognition of the right and the union security provision, and Victoriano versus Elizalde, including Reyes versus Trajano. Do you have any questions? All right. If you have no questions, you can now take a look how did the court interpret these provisions. So in interpreting these provisions, you can group workers. The first group is workers with right. The second group are workers without right. And the third group are workers with right, but the right is qualified. I repeat, the first group of workers are workers with right. The second group of workers are workers without right. And the third group of workers are workers with right, with qualification. So that's clear. So you go to the first. Going back to Article 243, you will note that Article 243 defines this institution simply because the general statement, whether for profit or not, have to be clarified by examples. So, in the case of Far Eastern University Medical Center, the court ruled that non-profit institutions, employees, have the right to self-organization because the right is based on the Constitution and statutory provisions, and it is not negated by the fact that the institution is non-profit, non-money-oriented institutions. If you are interested in history, the old law did not allow unions in non-profit institutions because they were not, by definition, industries. But of course, non-profit institutions now are considered exempt from the provision, meaning all workers have a right to join. Now it says all employees. Again, you are forced to go back to Article 212 of the Labor Code on the definition of the term employee. An employee is defined as any person in the employ of an employer, and it includes any person who has a current labor dispute and has not obtained a substantially equivalent and regular employment. I strongly suggest that you memorize the definition of the term employee because it is a term you will meet almost in every provision of the Labor Code. Well, there is something paradoxical in it. The paradox is that an ideal bar examination should not be an examination in memory. It should not also be an examination in enumeration. But unless you know the definition and you know that the enumeration, you'll find it pretty difficult to answer the questions. All right. Now, having said that, how about members of religious groups? What is the point of collision? The point of collision is the Constitution and the statute does not make a distinction on whether the employee is a member of an organized religion, is God-fearing or not. I am aware that I am in very holy. I am aware that I am in very holy ground. It happens to be a Catholic institution. I am not discussing religion, to be sure. I respect your religious beliefs, but I have to discuss it from the point of view of law. There is, as you will know, freedom of religion as a constitutionally guaranteed right. But there are also instances where the religious tenets or the doctrine of the faith does not allow its members to join any organization, any institution other than that of the religious sect. And it includes labor unions. So, the conflict is between the worker and the guaranteed right of self-organization, and on the other hand, a union security provision. can you compel the worker whose religious faith prohibits the worker from joining a union? That is the problem. The first rule says, and that is kapatiran sa mitati. When a worker whose religious tenets prohibits the worker from joining any organization, and the worker joins the union, the choice was made by the worker. And if the choice was made by the worker was only exercising a constitution and statutory guaranteed right, and the law will not interfere. That is the first rule. Meaning, if the worker made the choice on his own voluntarily, despite the religious tenets of the religion to which he belongs, the court said the worker is only exercising his rights under the law, and the law will not interfere with the worker's choice, freedom of choice. Second, what if the worker does not want to join because his religious tenets prohibit him from doing so? Now, just a note of caution. In your textbooks, you have Victoriano versus Elizalde. But you will note that in Victoriano versus Elizalde, you were talking of an amended law which exempt individuals who belong to a religious group from joining the union if it is contrary to the religious tenet. That has not been incorporated in the labor code. However, constitutionalists believe that in the hierarchy of values, freedom of choice in religion is supreme over the right to contract, which means, therefore, they are free to join or not to join, and the state will not interfere. At any rate, as long as you know the two doctrines. One, freedom of choice exercised by the worker, and the choice is in the exercise of the Constitution and the statutory guaranteed right, the state will not interfere. Second group, there is a freedom of choice. The choice was made not to exercise the right because it's contrary to one's faith. Even if the law is there to compel them to join, the law will not compel the worker because freedom of religion in the hierarchy of rights is a constitutionally guaranteed right. Now, government corporation employees. You will note that the reading of Article 244 makes no distinction between government employees performing purely governmental functions as well as government employees performing proprietary functions. But if you read the Constitution, Article 9 on the civil service, you will note that employees of government-owned and controlled corporations with original charter are by definition government employees. And a distinction is therefore made with the other group, government employees, or those in government-owned and controlled corporations, but they were created under the general law of incorporation. That distinction is important because for the first group, the labor code will not apply. For the second group, the labor code will apply. Hence, you have to make that distinction only for purposes of what governing law is all about. But for purposes of the Constitution, the constitutional guarantee extends to both classes of workers. It is only a distinction for the purpose of determining which law will apply. Clear? Now, supervisors. Again, I will have to ask you to read Article 245 and Article 242. Take a look at it. Right now, it will serve you a very good purpose if you read it quickly so you can follow the discussion. I'll give you 2 or 3 minutes to take a look and read at it. Articles 245 and Article 212. The key, therefore, is to understand the definition of a supervisor. Because until and unless you fully understand the definition of the term supervisor, you can easily be misled. First, the law says supervisors have a right to join the union under Article 245, provided the union is exclusively of supervisors. You will now note, therefore, that by definition, a supervisor is an employee. But the intention of the law is do not mix supervisors and rank and file in one labor union to avoid a conflict of interest. The design or defined conflict is in bargaining, in discipline, and in strikes. So there is, therefore, a recognition of the right, but the right is limited in the sense that the union must be composed exclusively of supervisors. The reason behind is to avoid a conflict of interest. And the conflict of interest lies in the area of contract negotiation, strikes, lockouts, and discipline. So the whole key, therefore, is understanding who is a supervisor, because if the individual is not a supervisor by definition, the individual is rank and file. And if he is rank and file, the basis of the right is Article 243. If the individual is a supervisor, the basis of the right is Article 245. Clear? So, what does it say? Yes. So you have to cut down into small component parts a supervisor. First, who is he? The supervisor is any person acting in the interest of the employer. The key phrase, acting in the interest of an employer. Second, when the individual is acting in the interest of the employer, it is demonstrated by certain acts. And the acts are enumerated in the law. And you will note that the acts have something to do with labor management relations. Thirdly, and this is the crucial point, when the supervisor, acting as an interest in the interest of the employer, performs the acts, the supervisor is using independent judgment, not merely clerical in nature. The use of independent judgment, not merely clerical in nature. And lastly, in the performance of those acts, he effectively recommends. You will note then that a straight memory work of the term supervisor is of value to you, but it will be of greater value to you if you are able to cut it down to small pieces. The first, in whose interest is he acting? Second, what are the specific acts that he is doing? Thirdly, in doing so, it is not merely clerical, It requires the use of independent judgment, and lastly, it is effective. Those terms should be fixed in your mind, because until and unless you know it, you are liable to fall into the trap that the individual is rank and file rather than supervisor. So first, acting in the interest of an employer. The law does not require, or does the law require, an employer-employee relationship? It does, because the supervisor is by definition an employee. Second, what are those acts? It's memory. The third is the most crucial, that it requires independent judgment, not merely clerical in nature, and it is effective. Which brings you now to the rule. The question that will be asked is the power present, is it effective? Is the power present, but it is ineffective? That is your formula. Your formula would be, is the power present, is it effective? Is the power present, but it is ineffective? If the power is present, but it is ineffective, it means only this. The person alleged to be a supervisor in exercising allegedly the supervisory function is not really free and independent, because the recommendation is subject to review by higher authority. Therefore, the power is present, but it is ineffective. It's ineffective because there is the power of review by higher authority. That is the key to understanding the supervisor. At this point in time, I have to call your attention to the amendment of the law. The law as amended now allows supervisors and rank and file workers, despite the provision of Article 245, to affiliate with the same national union. That is an amendment to the law. Which brings me now therefore to the point that you can forget substantially Adamson, Atlas Lithographer, and the La Salle University Medical Center. I repeat, under the amended law, or under the amendment, the supervisors union and a rank and file union can affiliate with the same national union, and if they do so, there is no violation of Article 245 of the Labor Code. Clear? Because of the importance of the supervisor. Do you have any questions? No, better still, if you have no question in writing, you can put them, and if you have no question to ask verbally, for reasons of your own, you can put your question in writing. If I do not answer it today, I'll study it tonight. Try to give it to you tomorrow. All right. Is there any question with supervisors? If you have no questions with supervisors, then the question of alien. An alien enjoys the right of self-organization under Article 269 of the Labor Code. If the alien has a valid working permit issued by the Department of Labor and Employment, meaning if the alien has a valid working permit under Article 269 of the Labor Code, then that alien can exercise the rights of trade union activity as defined in Article 270. Clear? And finally, you have the case of security guards. Now, security guards question needs a little explanation, because nowhere in the law as amended do you find a statement that security guards have the right. The old law, prior to its amendment, incorporated a prohibition limitation, but with the amendment of the law, in the case of the Manila Electric Company, the Supreme Court said, since the law has been amended, the effect of the amendment was to delete the prohibition, and therefore, by implication, their right is restored. However, if you are reading the Meralco Doctrine and you are applying the Meralco Doctrine, you have to be very careful because the Meralco rule went further. The Meralco rule said security guards, by the way, the security guards employed by Meralco in this case were not security guards under an independent contractor. They were direct employees of the Manila Electric Company. It doesn't really matter, but it mattered because who is the employer in this case? The employer is Meralco, and it is not the security agency. But you will note that, like any other employer, Meralco had several employee grades: supervisors, managers, rank and file. And the court said, because they now have a right to self-organization, those security guards who are supervisors can join the supervisors union of Meralco. Those security guards who are rank and file can join the rank and file employees of Meralco. And the Supreme Court woke up and said, what have we done? What have we done? Because there is the haunting memory. Separate them to avoid conflict of interest. Now we join them in the conflict of interest and write them to reality. After all, whether you read the great book or not, you have heard of the ancient saying, you cannot serve two masters at the same time, right? The first master is the union, the second master is the employer. But the Supreme Court, the last resort of error, the Supreme Court of error, because after all, your only appeal is to God, if and when the Supreme Court refuses to change. Well, the only reason I am able to say that is this very room is part of the will, and it will extend academic freedom to me. Maybe elsewhere I would not have said it. But the court said, but you see, the error is not ours. The error is in the law. So like St. Peter, before the cock crowed 3 times, St. Peter denied and washed his hands, right? And so the court said the remedy lies not in the court. The remedy lies in the lawmaker. Therefore, what is the remedy? The remedy is follow Article 245 on the rule of the supervisor. All right? That takes care of all employee grades with right to self-organization. To recapitulate, all employees, non-profit, questions of religion, questions of supervisors, question of aliens, questions of security guards. Now, by extension, you have the rule on managerial on confidential employees. You will note that under Article 245, managers and managerial employees do not enjoy the right of self-organization for purpose of collective bargaining, but they enjoy the right for purposes of mutual aid and protection. But there is a line. If you cannot bargain, you are there only for what reason? For mutual aid and protection. But of course, you join because you want to bargain, right? Managerial and confidential employees. I am sure Professor Alcantara has said it very well. I am sure he asked you to memorize Article 82 of the Labor Code. Because Article 82 of the Labor Code is a definition of managerial employee. And Article 212 and 245 also define it. Note, it is a functions test. What are they doing? The Supreme Court, by the doctrine of necessary implication, included confidential employees in the same manner as managerial employees, with one limitation. Not all confidential employees are covered by the rule. I repeat. While the doctrine of necessary implication said that confidential employees are akin to managerial employees, not all confidential employees are covered by the akin rule. Clear? So where is the distinction? The distinction is confidential employees who, by reason of their work, meaning an integral part of their work and not merely incidental, have access to confidential information involving labor management relations. That is Group 1. Group 1 is confidential employees who, by the very nature of their work, as an integral and not merely incidental part of their work, have access to confidential information affecting labor management relations because they assist a confidential employee in doing so. The second group are those employees who have access to confidential information, but the confidential information has nothing to do with labor management relations. So where is the line? The line is access, labor management relations, confidential information. The second, access to confidential information, not of a labor relations matter, but any other matter, even if it is confidential. That line absolutely must be fixed in your mind. You cannot have the luxury of not knowing where the line is. If you do not know the line, you cannot answer the question. So where is the line? The first line, workers confidential. Why are they confidential? Because they assist somebody in a confidential information. And by assisting the confidential employee, they have access as an integral part of the job, not merely incidental, to matters affecting confidential matters on labor management relations. And therefore, this group do not have a right to self-organization for purposes of collective bargaining. The second group, employees that have access to confidential information, but not of labor management relations, meaning they have access to market information, they have access to manufacturing information. The rule does not apply to them. They have the right of self-organization. Therefore, what you are expected to know is the meaning of the access test. Access, not merely incidental but an integral part of the job and the nature of the information affecting labor management relations as distinguished from information affecting non-labor management relations matters. An example is access to manufacturing information. So, you have taken care, therefore, of confidential employees. Now, how about employees of cooperatives? In the case of employees of cooperatives, you have to make a clean distinction. The distinction is, one, where the employee is only an employee of the cooperative. The employee enjoys the right of self-organization. Second, where the employee is also at the same time a member of the cooperative, that worker does not enjoy the right of self-organization. By judicial doctrine, the second group has additional rules. First rule, it is not that the worker does not participate in the management and the operation of the cooperative. The prohibition is based on ownership. The prohibition is based on ownership, not participation in the affairs of the cooperative. Second, if there is in the contract of membership that is deemed to be valid in terms of procedure, namely how to leave the cooperative, the contract will be enforced, because the contract cannot deny the worker the right to resign, because by resigning, the worker is only manifesting a desire to exercise a constitutionally guaranteed right. But the cooperative has the right to insist, if valid, that the procedure for resignation must be complied with. And lastly, the prohibition refers only to the worker. It does not include the next of kin. So you have cataloged all, you have cleaned all types of workers. And the party that is protected by law is not the labor union, simply because the labor union is simply the institution to protect the worker. What the law is protecting is the individual worker. When those rights are violated, you have the unfair labor practice provisions of the labor code to interfere, restrain, or coerce employees in the exercise of their rights guaranteed by law. And there are civil and penal sanctions provided for in the labor code. To recapitulate them, it is imperative that you know the constitutional basis, and that you also know the statutory basis and the judicial doctrine. It is a right specifically ordained, not merely derivative, and it is a right of paramount value that cannot be denied on nebulous grounds. Second, you are expected to know the extent and scope of the right, meaning the positive statement of the right and the negative recognition of the right. Thirdly, the classification of the workers, the limitations imposed by law, and the prohibitions. And when the prohibition is there and in place, the prohibition refers only to collective bargaining, but not to mutual aid and protection, for the very simple reason that Article 243 distinguishes self-organization for purpose of collective bargaining and self-organization for purpose of mutual aid and protection. So do you have any question? It's a tedious process. It's like buying what you see in the province, not a comb used by whoever uses it to remove the lice, L-I-C-E. Hindi, parang sugod, yes, sinuyod mo. That's exactly what we did. Do you have any questions? Do you have any questions? All right, as I was trying to point out, you have to cut the law into small pieces. You cut them into small pieces, you have a major subdivision. And the major subdivision, you have to cut it down to smaller ones. In other words, it now becomes manageable. But if you sit down and memorize Article 243, I can assure you, even if you memorize it word for word, you have to use your imagination how to cut it down to small pieces. How do you cut it down to small pieces? That's exactly what we are trying to do. Do you have any questions? Do you have any questions? All right, you can take a look at your notes. If there's any area, if not in the form of a question, is there any area that you need further explanation? Do not complicate it. The instructions are very clear. The questions that can be asked in the bar examination are the questions which the lawyer will face on his first year of practice of law. That's why I stuck to the basics. Basic. It's like, it's like, if you are studying, I'm sure you did not, but for those who, like me, probably studied in a simple barrio school, public school at that, you remember the readers, right? I have a dog. My dog's name is Bantai. Bantai has 4 legs, 2 ears, 2 eyes, 1 tail. Come, Bantai. That's exactly what we did. Basic. Any questions? Every time you read the book, I assure you, there will be tears and laughter. Never mind the tears. That's the price you pay. Enjoy the laughter. That's your profit for the day. Any questions? Well, if you have no questions, that only convinces me that you're ready to take the bar examination tomorrow. If you are curious, would you like to answer my final examinations I did? The past academic year. The past academic year is 2009-2010 in my prelims and in my final. In labor standards and welfare and labor relations. You want to answer that every numerograph and just for the heck of it. No, the reason I ask you is I think all of your reviewers will tell you that examinations in the classroom are much more difficult. If you can answer them, you can also answer the questions in the bar. If you want, I'll have it. I can give it to Jason and I'll ask him just for the heck of it, just for the fun of it, not to torture you. All right, if you have no questions, I will have to move on. The second major area of concern of the law is labor institutions as organization of workers. Remember, the first area of concern is right to self-organization. But if the right is exercised, you must have an institution, and that is a labor organization. Again, to understand what is a labor organization, you have to go back to Article 211, big A, small a. No, 211, big A, small b, small c, small b. You will note that the reading of the policy statement takes care of three principal areas of concern. The first area of concern is what is the role and function assigned by law to a labor union so that they are valid institutions in society. That one was asked in the bar examination, and very innocent question, but it was asked. The question was, what is the role and function assigned by law to labor organization? And the answer is, a labor union is an institution for the promotion of social justice and the enhancement of democracy and national development. You will note that there is a function assigned by law to the union. It is to enhance democracy, to promote social justice and national development. But paragraph C now tells you what kind of a labor movement is expected. And the expectation is a strong and united labor movement. And paragraph C answers the question, what kind of workers? And it says that the workers must be enlightened. Enlightened in one, the provisions of their collective bargaining agreement. Number two, enlightened on the role of law in labor management relations. And for this purpose, you have Article 277 of the Labor Code, which authorizes labor unions to collect dues for the purpose of workers' education. Clear? All right. Now, definition. Again, you have to memorize what is the definition. If you open your labor code, you have to read it very carefully simply because Article 212 says, what is a union? It answers the question, it is an association. It answers a second question, association of whom? And it answers a third question, for what purpose? It is important because the implementing rules of the Labor Code now provide for a workers' association. But you have to read the provision of the Labor Code's implementing rules with respect to workers' association in the light of Article 243, the second group of workers. So first, it says, a labor organization is an association of employees. And the term employee is defined in Article 212. Second, the definition says, it exists in whole or in part for purposes of collective bargaining. It answers the question, what is the purpose? Now, if you are to cut it down, judicial doctrine tells you, yes, it must be composed of employees. But the thrust of the definition, the focus, the direction of the definition is not on the fact that they must be employees of a particular employer only. But the thrust of the definition is in purpose. And when you look at the thrust of the definition and purpose, you will note the phrase in whole or in part, which means therefore that the labor union can have multiple purposes. And even if it has multiple purposes, the character of the union will not be destroyed provided one of the purposes is economic in nature, meaning collective bargaining. In other words, you are liable to look at it from the point of view of corporation law. The primary purpose, the secondary purpose. The labor code makes no distinction between primary and secondary purposes because the labor code uses the phrase in whole or in part for purposes of collective bargaining. So, the focus, the thrust is that yes, it is composed of employees, but they need not be employees only of a particular employer. Because the thrust, the focus of the definition is on purpose. Purpose, you have to equate it. Multiple, it need not be. But as long as collective bargaining is one of the purposes, even if you have a multi-million purposes, it will still be a labor union. Collective bargaining is designed and defined as the process of negotiating wages, hours of work, and other terms and conditions of employment. Therefore, the thrust is purpose. Clear? Now, second, you have the definition of a legitimate labor union. This time, you have to fix in your mind that legitimacy is based on only one thing, registration. And second, registration only with the Department of Labor and Employment. It assumes legitimate status only if the union is registered with the Department of Labor and Employment. Registration with any other agency, for example, the Securities and Exchange Commission, as a non-profit institution, makes the union legitimate in the eyes of the SEC, but it is not legitimate in the eyes of the Labor Code. But you will also equally note that the Labor Code does not define an illegitimate labor organization. The Code does not define what is illegitimate. The Code defines only what is legitimate. Then the Code defines a company union. A company union is not what you understand it to be, a union in a company. No. A company union is a union defined under Article 248 of the Labor Code as any union, the formation, administration of which is organized and assisted by the employer. It is an unfair labor practice. Now let me introduce you to a phrase you do not find as such in the Labor Code, but it is there under another name, and that is a workers' association. A workers' association is defined under the implementing rules. Like the labor union, it is also composed of employees. But its purpose, you will know, is mutual aid and protection, because most of these have no definite employers, meaning therefore, if you read Article 243 very carefully, you will note at the bottom, mutual aid and protection. Correct? So you have defined all the terms. Again, I have to repeat. That's grammatically wrong, right? If it's again, it is repeat, right? But I deliberately did it just to emphasize that there is a discipline of the mind that is expected of you. I am sure you all remember Antibai versus Court of Industrial Relations, right? It's called the cardinal primary rights. If it's cardinal, it must be primary right. After all, cardinal is the red flag. You don't find them every day, right? Even if you walk the entire UST grounds, you cannot find a cardinal. Okay. Okay, so fine. Now, what is the union? You will know in Article 211, paragraph D, C, D. It is an organization of workers, but there is a function. But you will also note that if you look at it much deeper, the union is the institution that is the workers' institution designed to protect and promote their welfare. Now, there is the question of union registration. Let me call your attention that this is a burning international law problem for the Philippine government because the Philippine government ratified conventions on freedom of association and bargain collectively. Yet, at the same time, the Philippine government says a union must be legitimate, meaning it must register in order to exercise the rights provided for in Article 242. At this point in time, your focus should be principally registration under Article 234, 234-A, and 237, all in relation to Article 242. 242 is the statement of the rights and obligations of labor unions, and the fact that there is an amendment to the law that grants limited legitimate status to a union. The limited legitimate status means that if a union is a chartered affiliate, it's granted legitimate status limited for the purpose of filing a petition for certification election. Now, clearly, you should know what you are talking about. What law? 234. 234 is registration of unions that is not a national union. 237 is registration of a union that is a national union or a federation. 234-A is registration of a union that is a chartered affiliate. Clear? So you must therefore know which one to use if you are registering a union. All right. But you can make it very easy. Where is the line? The line is actually two lines. One, who is registering? A, 234. The union is not a national union. It is not a federation. 237, the applicant for registration is a national union or a federation. What is the difference between the two? The difference between the two is a national union or a federation is an association of unions. At least 10 unions. Each one is legitimate. Each one is a duly recognized bargaining representative in the establishments where they are located. Clear? Now, 234-A is clearly associated with Article 237 because 234-A is the chartered affiliate of 237. Now, you can simplify the whole thing if you just imagine that you have Xerox them all in acetate form. Acetate. So you put 234 and you put 237, one on top of the other. You will notice they are almost exactly the same, except on two things. In 234, the petition or the application for registration must have the support of a percentage of the union members. But in Article 237, the support is not a percentage but an absolute number. You will note, right? So, if you put it in acetate form, one on top of the other, or if you do not put it in acetate form but you type it separately and put them together, you will note that it's exactly the same in many ways. The government wants your money, so you have to pay a registration fee. Right? The list of officers and their addresses are the same. But you will note the support for registration vary. And lastly, you will note the books of accounts and financial statements that must be supporting. It is the books of accounts that has been amended, which means if the union has been in existence for less than a year, the financial statement must be presented, but not the books of accounts. Excuse me, if you will notice, there's a very loosely stated statement. I did it deliberately, so I force you to open your labor code. Open your labor code in Article 234 and note very carefully, is a financial statement the same as a books of accounts? Well, someday, should you ever lose your sanity and you agree to become a professor of law, God bless your students. You will not. That you must be able to wake up your students when they're sleeping. And the only way to do that is to deliberately make a mistake. Then you will know if they're awake or not. If they did not notice it, that's not the story. Look at it, look at it, look at it. There is a statement, books of accounts and financial statements, right? So the question is, when are you exempt from attaching it in the application? When are you not exempt? And what is exempt? There is a dividing line. Is it 1 year or is it more than 1 year? Or is it less than 1 year? Don't tell me that you do not know simple arithmetic. The law students love to say, sir, if I was good in math, I would not be in law school. But I can assure you that the very good lawyers in some American law schools began their careers as mathematics majors. All right, take a look. Is there a difference between books of accounts and financial statements? Here. Excuse me. How many of you are holding a textbook? How many of you are holding a textbook in labor law? Or how many of you are holding Professor Alcantara's magnum opus, reviewer in labor law? It's a thick one. Green is the color. How many of you? Well, how many of you are holding the abbreviated version in the most abbreviated form? It looks like a bikini bathing suit. Essentials of labor law, or everyone's labor law. If you are holding, no, I'm not. are not having fun, you open Article 2, 3, 4, and note there are possibly two cases. One is Progressive Development Corporation, and the other one is Pagpalain Howlers. Pagpalain overturned Progressive, and Pagpalain is now codified in that provision of the law. All right, you can have a break, I suppose. The mind is already tired. So you can have a break. You can come back at 10:15 or 10:20. Okay?
Amended na ba? Tulong... Ano ba natin ulan? Ang bilis mo nga Dayan eh. Ano yung ulan? Yun din. Yan na, ulan mo. Bago na ba? Daw? Yung sinasabi niya? Oo. Yung 2008 na version. Kasi 2007 pa lang. Oo, kaya pa naman yung atin yung... Ha? Hindi, may amendment lang. Kaya pala iba yung sinasabi niya. 2007. 2008 yung amendment. Meron.
tayo magsinulit. Meron pa may
Ako, financial report. Financial report pa. Dapat yung bago na talaga.
bago rin naman may 234A na yun sa akin.
Ayun sa'yo, pareho lang.
234A na.
Kaya, di ko mahanap pero
Financial pa rin.
Hindi nga po yata yung sinasabi niya.
Yun nga, oo, yung kasa ata. Yung sinasabi niya,
Kapatid, sinakayat ko nga, wala kasi 2,000. Security? Wala pa, so online to eh. Paano pag hindi siya.
pero di ba sige may case tayo? Ay, hindi talaga. May case tayo sa labor eh. Di ba Kuya? Yung security guard.
Pag independent.
Pag independent, yung mahabang case, sabi,
Tapos,
ano doon? Yung case, yung parang sabi nga,
yung Meralco.
hindi, yung may case tayo sa labor.
Ano nga yung sagot nun? Pwede pa rin o hindi? Pag independent ka sa
Ang parang doon sila maboto ata sila sa
Ako pa rin yung oo, parang sa ganun na.
Diba? Di binapaboto sila sa
Pwede kapag
tandaan mo, Linis.
pero yun nga, hindi ko nakuha. Parang dito kasi sinabi.
Ha?
Ano kasi sinabi? Ano yun? Yung sinabi niya lang kapag supervisory yung yung security guard, kasama siya dun sa union ng Writing Jing na oo. Sinasabi niya. Pwede siya sa
Tama nga naman.
Pwede siya lang magkama. Hindi, security guard, no, supervisory. Pwede siya sumama dun sa supervisory nung na hindi,
Tapos kapag yung security guard na rank and file, doon siya sa rank and file.
file lang. Hindi pa rin pwede magsama ang rank and file.
Wala, hindi na sinabi ko.
With respect to security guard. Oo. Hindi pwede magsama. Unless, pwede sila sumama.
Interest na, diba? Yun sabi niya, yung error daw.
Diba may gano'ng amendment? May sinabi siyang ganyan, pero hindi dun sa isang part.
Oo.
Shit.
Doctrine ba yun?
Will of the parties yung...
Kung gusto mong sumali o hindi.
Yun yung amendment na sinasabi mo, Chiki.
Oo, yung
Supervisory union and rank and file can affiliate with the same national union. Pero iba yung sinabi niya sa security guard. Pwede lang sa pag-supervisory security guard. And the rank and file employees. If the security guard can join, sabi niya eh. Lumalala si Kuya. Rank and file employees.
Kuya.
Kuya. Alright.
Agency.
Kuya, agency kayo? May agency. May agency kayo, Kuya? Huwag mo naman dito. Ay, wala. Sabi sa independent. Hindi pwede. Independent contractor, hindi pwede. Agency kasi si Kuya, ibig sabihin, sa direct employee na yun. Si Kuya lang pala makakapagliwanag. Kapag employee na. Direct employee. Kaya yun yung naisulat ko.
Yun na yung may kaso na.
Hindi pa tayo.
Yun nga tungkol din sa mga security guards.
Talagang Kuya. Sinuda ka naman. Ay, kuha rin ng tubig.
Ay, hindi mo pati. Ang kaya naman. Ha? Dayan, pero hindi ko naman pwede
Maliban pa dun, meron siya hindi ka tinatanggap o mga ganyan. Bibihira kang tanggap o mga ganyan.
Hindi ko alam, di ba? Panira ba sa umaga? Oo, mas maganda rin yun. Yung rather than complicating yun. Pero may temptation pa din na, ano yun? Oo. Oh, sino? Hanapin ko siya. Try ko. Pagpala, 240. Pala bumagsak din ang yun. Time consuming. DJ. Kaya pala bumagsak mo yun. May ano ka pala, may stress ka pala maging beauty secretary. Ayoko, ganun na position. Ba't yun sa bago? Gulat ka. 803. Kung matitemp ka, yun just go. Pero kapag wala na, stop ka na. Never change. Pero wala sa Hindi tubig. Wala na rin? Ang saan? Sige, ano ba yan? Ano na rin na mamaya? Ikaw? Wala ko nilapit ka sa may... Wala mo ba ko na rin? Wala ko nila. May dala ako kapo. Chiki, kailan deadline daw?
Hindi ko alam. Wala akong dala eh. Kung nakalimutan. I-picture ka rin. Oo, ganito. Saka yung kuwan. Ay, linipinito ka na. Tara. Babayad ka pa lang. Wala ka pa rin. O sabihin mo, kasi yung pag-i-finish. Kaya tamad ako. Mabilis na. Magkasabit ka. Hindi.
Pero wala ka na mga
Yan ba?
Hinintay mo kasi kung ano ang application.
Parang dito ko
ginawa.
Ito rin.
Ito meron. Para ma-segregate. Ay, parang hindi na ba? Kasi hindi ka makakalit. Hindi ka makakalit. Pero mali din eh. Kasi test mo. Kaya pag scan mo sa basta yun. Tapos yung second reading. Oo, atin lang yung second reading. Yung na pala yung ikaw ka na.
Alam mo, awas ka lang yan. Ang tanong yun.
Pero pag mapakalitan, lahat ng mga
Paano mo? Siyempre sila pa rin.
Hindi naman kung magkakakati ba?
Ako hindi pa.
For the next.
Eh, pamaya lang ka na.
Kasi hindi ko mapakalihan ng kakain. Kasi habang nandiyan ang material, the more na material sila, kasalit ka rin. Dito ba? Nandito ba? Nandito
Wala pang gawa. So, parang kami nakailak. Basta, wala. Hindi ba? Ano yan?
Ito lang dala ko. Here. Meron yan. May ano na ako. Gusto mo na palit na nung ano. Pasensya ka kung talaga. Oh, eto na. Meron marami yan. Sabihin mo ba?
Ay, sa Friday, no? Ako, gusto ko make-up ang nila. Magaling ako. Totoo, akala ko joke naman. Make-upan mo ako after review. May party kami dyan sa namin. Akala mo naman. okay na yung may eyeliner na ako, mga eyeshadow, ganyan yung kilay ko, yung chin ko.
Updated si Mahon sa mga party list. Gutom na ako, sir. Hindi ko na ma-absorb yung... Kasi wala ka ng food.
Ano lang,
Juicy.
Kamatay, gutom.
Diyan lang, nag-CR.
Bakit sarado?
Ako din umakit.
Ito mo ba? Dalawa doon. One by one.
Tingin. Ay, mag. Ang ganda. Saan ako dito? Ba't kailangan ko ba ito?
Para dun sa shore.
Ano ba ito ba?
Ay, one by one yan. Sagutin ni Kuya Rai.
Mga
Malaki.
tsaka one by one.
Of course yun.
Ang ganda-ganda nga. Picture ko sa ano?
Hirap na. Namumuna pa.
Kasi kasama sa
Gusto ko ng Tagalog, pinapakilaman. Kasi ito perfect ito. Sabi ni ano yung balik ka ba? Ito
sino ba?
pakila pero hindi pag Tagalog gagawin niya English.
Hindi niya ako palagi pwedeng i-text kasi kasama ko yung asawa niya.
Siyempre naman, masyado na.
Ano ko ba?
Some understanding.
Business transaction naman yun. Saka, wala mo na hindi na tayo nakaano naman.
Meron pa kami.
Saan nagre-rate? Ang dami subdivision na naman. Lakeshore.
Parang lake house lang yan.
Naiintindihan ko yung concept. Saan?
Ayoko na bago alay.
Gusto mo sa Tagaytay? Text natin yung answer ko doon.
At try, hanapan mo nga ng ano.
Habang answer ko dun si Willie. Si Willie Revilla.
Nakita namin yung bahay ni Kuya Revilla.
Meron siya sa Tagaytay Highlands, diba?
Tapos nakita namin sa Highlands kasi isang araw sabi doon. Bakit pala yung kanil? Tapos ang kwento ko bahay ko, parang isang malaking bahay. May mga pizza diba? Tapos yung kotse na sobrang dami. Basta lahat ng mga iwanan niya doon. Hindi na sobrang dami yung garahe niya. Sobrang yung garahe niya. Meron siya baka doon siya nakatara. Tapos glass house.
At ito nga yata yung hindi yung yata yung mga
Hindi naman pinili kasi dati parang binibigyan mo nga lang yung tulong na dolphin. After nung one time shooter. Ba yun? Oo. After noon, naging na nga binibigyan na nga may cover naman.
Kung matagal na. Hindi ka ba na timing nun? Hindi pa. Kadiri.
Baka kasi yung mga bigay na may ilalagay.
Hindi. Muna na yun.
Yung mga sleeping rest.
Ang renovation.
Harbor Beach. Kasi kayo mag-aano lang. Kayo mag-aano lang.
Malapit ko sa
Ikaw yung mag-aano lang. Naka-ano yun?
Pinag-visit. Alam mo, isang araw ko pinag-visit kita ni Jay. Kasi nung pag-visit kaya wait, is the application of privacy? I'll sue you.
Hindi mo pwedeng i-invoke yun kay Dayan.
Privacy communication. Hindi naman public communication.
Sino Dayan? Carlo? Stephanie, ha? Si Marcel.
Si Carlo, manyak binubok na. Hindi okay na kay Carlo. Wala ka ng mukha niya. Plus na.
Stephanie, ha? Sino si Carlos, Steph?
Yung taga-Angeles. Kailan ka ba naman magkaka-interest na hindi guwapo? Hindi ko siya interesahan. Ano? Nalahiyan ako. Siya yung nalalahiyan sa'yo? Oo. Nadahimik ka. Nadadating ka na. Kaya ba laging ganyan yung mga suot mo? Wala pala. Tama. Sabi niya, hindi siya siguro. Lagi. Okay naman umaya na lang. Nahulog din takip. Unsa man dahil? Sa paper ang lalim. Pero si Kacho. Yan.
I am not criticizing the Supreme Court. I only said that the Supreme Court can be the Supreme Court of last error. If you will remember years ago, a lawyer, in his complete frustration, bought a one-page or a half-page ad in the newspaper, and the title caption was, "An Appeal to God," because he was frustrated with what he felt was a wrong decision. Of course, you know what happened next. He was held in contempt, right? And the third time or the second time he did it, the Supreme Court suspended him from the practice of law. Second, this is not a classroom. If it were a classroom, the technique of legal education would be different from a bar review. In the classroom, you can analyze the decisions and you can tear it apart till kingdom come, and there is no damage done. For the simple reason that legal education is a two-way process, meaning you have a right to criticize, right? That's the reason why you have law reviews. But for purposes of the bar examination, you do not criticize a decision. You just simply apply it because that is the question, right? So let me clarify. Meralco, reading the decision, will tell you two things. One, tracing the history of the law. The court came to the conclusion that security guards now have a right to self-organization. Why? Because the historical development of Article 245 of the Labor Code originally contained a prohibition. But the amendment removed, retained the number, but placed something else. But there's a second part of that decision. The second part was an interpretation of the implementing rules. Although when Supreme Court said that there is a concern of mixed union, meaning since the employees were employees of Meralco rather than an independent contractor, they now have to join rank and file or supervisors unions in Meralco, which brought the Supreme Court back to its original position. Since we have identified an evil, we are back to that evil. But you see, the Supreme Court said the remedy is not with the courts. The remedy is to amend the law. All right? I should not have done it, to be sure, because this is bar review. If I did it, it's only because in my mind there is that statement that it is an analytical question. I shall refrain from now on from telling you the area of controversy. That's the safest way for me. All right, to go back. I was pointing out that there are three methods of registration. 234 covers the situation where the applicant is an independent union, not a federation, not a national union. And Article 237 covers the situation where the applicant is a national union or a federation of unions. And you will note that what distinguishes 237 from 234 is that 237 is an association of unions, 234 is an association of workers. And you have 234-A, which is a chartered affiliate filing an application, and the chartered affiliate is related to Article 237. For historical purpose, if you wish, 234-A is not brand new. That 234-A is a codification of existing judicial doctrine as progressive development in your old textbooks. All right. Now, but I wish to call your attention, there is no such thing as a national trade union center. What you have is a federation, a national union, and now that's clear. Now, but 234-A, 237 is associated with Article 235 and 236 because 235 is the agency where you file and the appeal procedure in the event that the application is denied. Clear. But what is important is recent judicial doctrine tells you that while it is true that the function of the Bureau of Labor Relations as a registering agency is ministerial, ministerial means that the applicant has complied with all the essential requisites and requirements, and mandamus will lie to compel registration. However, recent judicial doctrine tells that the Bureau of Labor Relations, in the performance of its registration function, is not an automaton or a mechanical agency, meaning the Bureau of Labor Relations has the right to scrutinize, examine whether there is compliance with all the requirements of law, meaning the Bureau of Labor Relations has the right to inquire on the validity of the documents submitted, and number two, to verify its authenticity. Now, where is the problem? The problem is this: the right to self-organization is both a constitutional and a statutory guaranteed right. However, there is Article 242 that seems to be the area where the controversy is. Why? Because registration confers legitimate status, and Article 242 is titled Rights of Legitimate Labor Organizations. And the term legitimate is defined in Article 212 as a union that is registered with the Department of Labor and Employment. So you see the connection. The connection is 212, legitimate, registered. 242 is rights of legitimate labor organizations. And therefore, the implication is, if the union is not registered, it cannot avail of 242 rights. If it cannot avail of Article 242 rights, where will it collide? It will collide with the constitutional guarantee as well as the statutory guarantee of freedom of association. There is where the collision will take place. And two cases, one, Philippine Association of Free Labor Unions versus the Secretary of Labor, and secondly, Villar versus Incheon. While it is not part of your labor law review, I am just simply informing you that this is the question where the Philippine government is the respondent, before the International Labor Organization. The unions have been questioning the validity of that requirement. In fact, 3 months ago, you would have noted in the newspapers that a high-level official of the International Labor Organization, which I am sure you have studied in your international law courses, came to the Philippines to precisely study the question. Now, where is the conflict? The conflict is if a labor union is not registered with the Department of Labor and Employment, the law does not say it is illegitimate. But the law says you cannot avail of the rights granted in Article 242. Hence, it is necessary that you read what Article 242 really says. If you read Article 242 very carefully, you will note that the most important right there, and I say most important, it's a relative value judgment on your part. If a union is not registered, it cannot be certified as the exclusive bargaining representative, which is the starting point for collective bargaining. So the provision of Article 242, which says that the union will represent its members, is not exactly correct. Because under the doctrine of fair representation, a union will represent, if it's the exclusive bargaining representative, all the members of the appropriate bargaining unit, whether they are members or not. Secondly, there is the right of the union to be furnished financial statements for purposes of bargaining. And thirdly, there is the right of the union to be exempt from taxation from any form of donation. And you will note that the right in Article 242 is so tightly worded in such a way there can be no general repeal of that right. It must be a specific repeal. In other words, it's an exception to the general rule of repeal. So you can understand why it is important. Now here, because of the importance of the question, I try to explain it to you as detailed as I possibly can. First, Villar versus Inchong reiterated what was said in Philippine Association of Free Labor Unions. The first statement, which you should know by heart, a labor union can exist with or without registration. I repeat, a labor union can exist with or without registration because unions are valid institutions in society. The second, but unions must register in order to avail of the rights granted in Article 242, which brings you now to the core of the decision. Article 242 is a catalog, an enumeration, a litany of rights of a legitimate labor organization. But when you compare Article 242, namely the rights, and you compare it with Article 13, Section 3 of the Constitution, which is the Labor Protection Clause, and the Bill of Rights provision on the right of self-organization, you will note that the Constitution does not enumerate any of the rights mentioned in Article 242. In fine, they are statutory rights, not constitutionally guaranteed rights. Because there are only statutory, not constitutional rights, the court now said one must register in order to avail of these rights. In fact, the court used a Latin phrase. I don't speak Latin, although I was sitting down in front this morning, and I look up on top of the building, I saw a Latin blah, 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 blah. Well, anyway, the Latin phrase used by the decision is condition sine qua non. In simple English, there must exist before you can exercise, right? Which means you cannot, as a union, exercise those rights until and unless you are registered. And the court said, you want to avail of the rights of 242, fine, register. If you do not want to avail, the law will recognize the union as a union, but it cannot make use of 242. In other words, there's a carrot, there's a stick. You want to, this is. And finally, the court said, if you have any yet doubt whatsoever, this is a valid exercise of the police power of the state. Now you cannot quarrel with the police power of the state. And of course, I have no doubt in my mind that many of you would have memorized Judge Cooley's classic definition of the police power of the state. But in simple language, in simple English, in pedestrian like me, police power is the authority and the right of the state to promulgate rules, laws, regulations for the common good and the common welfare. Although when I was a freshman in law school, taking a course in constitutional law, our professor, perhaps in exasperation, because we had to recite Judge Cooley's definition, said, here, I will illustrate it to you. He said that in 1935, when they were discussing the then Constitution, one assemblyman, they have not changed over the years, he stood up and said, are we not giving too much power to the policemen? He equated the police power as the power of the policemen. Or of course, you know that that's true. I'm not saying the policeman is bad. All he said is that in the ordinary layman's definition, policeman is the power of the police. But that's not what a law student will tell you what it's all about. Which brings you now to the full conclusion. Registration is not a violation of the Constitution and statutorily guaranteed right of self-organization, because the court made it clear that the union can exist with or without registration. But secondly, the way the court built the decision, the way it constructed the theory of the case, is very simple. It began with saying whether you are registered or not, you remain to be a union. Because in the eyes of the law, a union is a valid institution. But if you want to exercise the rights granted by law, which are not constitutionally guaranteed rights, you have to comply with certain requirements. That's why you have the Latin phrase, condition sine qua non, which means register, then you can avail. And there is no violation because 242 is not a constitutionally guaranteed right, but is a statutorily guaranteed right. Clear? In other words, is it clear? All right. If it is clear, you now brought to why should you register? If registration is only for that purpose, why should you register? Which brings, it's inevitable that I have to explain the rationale simply because of the threat that The questions will be analytical, right? So it means, why should you register? Register is to protect. Who is to be protected? The worker, the employer, and the public. From what? From fly-by-night union operators. And therefore, it is a protective device, a device set by law to protect the public, the employer, the worker from fly-by-night operators. In other words, it is there to protect you from abuses from other parties. Now, the question of legitimacy. You have the basic rule. Once a union is registered, it assumes legitimate status at the time the application for registration is approved. Once approved, the union is legitimate and will continue to be legitimate until its registration is cancelled. So once you legitimate, always legitimate until cancelled. And you have the no collateral attack rule. The no collateral attack rule says that the legitimate status of the union cannot be attacked collaterally, meaning the due legitimate status of the union cannot be attacked in a petition for certification election. The attack must be direct, meaning the attack must be in the form of a petition to cancel the certificate of registration. Now, when is legitimate status conferred? There are 3 dates that you have to reckon with. The day the application is filed, the day the application is approved, the day the application is received as approved by the applicant. The crucial date is the day it is approved, not the day it is received, before or after. Now, since you are talking of legitimate status, bear in mind you have limited legitimate status under the amendment of the law, which means what? A labor union that is a chartered affiliate of a legitimate national union has limited legitimate status only for the purpose of filing a petition for certification election, but does not enjoy full legitimate status under Article 242, because full legitimate status will be enjoyed only after the union has filed the other requirements clear. So there is limited legitimate status, limited only for a legitimate purpose, and that is filing a petition for certification election. Clear? Now, what are the rights of a legitimate labor union? They are simple memory work. But I have to call your attention that there are certain things that you must clarify. It is not correct to say that the union can only represent its members. No. Because under the doctrine of fair representation, a union that is the exclusive bargaining representative must represent all members of the appropriate bargaining unit, whether they are members of the union or not. But an important right is built in Article 242, and that is the right to be furnished financial statements as part of the duty to bargain, and the financial statements must be submitted and furnished by the employer to the union. Note there are time frames. The time frames are important because only within that time frame can you as a union demand financial statements. But for purposes of the law on taxation, read that portion of Article 242 on repeal of tax exemption rights, because it is so tightly worded that to repeal that right, i.e. tax exemption, a general repeal of a tax law will not be available. It has to be a specific repeal. Clear. Now, if a union is not registered, then automatically it cannot avail of the rights of it cannot avail of the rights of Article 242. So you will note that there is an inducement to register. There is also a negative effect. All right. You ask why. All right. You don't have to write it down. You can forget it after I said it. Registration historically, the world over, not just the Philippines, has always been a bane, a fear of all unions, because registration is a form of government control. That is the reason why unions do not favor it. But the government says, you must register because we have to protect some people. In other words, you got both sides of the story. The side of the union and the side of the government. Now, but God is really very merciful. If you look at Article 239 of your old labor code, the 11 enumerations are gone. There are only 3 more left, and that's Article 239. It is an amendment to the law. It is an amendment to the law because the grounds for registration are misrepresentation, false information with respect to certain documents, and they are repeated. The last one is voluntary cancellation of certificate of registration, which means you have to forget all that you have learned in law school. God is merciful. You don't have to memorize the 10 grounds. Clear. Now, cancellation of the certificate of registration. What the amendment provided for is limiting the grounds for cancellation to only 3, but it did not repeal the procedural due process for cancellation, meaning a certificate of registration cannot be cancelled without according procedural due process as well as substantive due process to the union. That is clear. Now, and a petition to cancel the certificate of registration is simply a petition. It does not decide, and the decision only comes when it is final that the cancellation is to take effect. Now, for one reason or another, you read Article 241 very carefully and take a look at the provision in special assessments and extraordinary fees. May I ask you to read NOP of Article 241. We'll do it step by step. Here, before you read it, the title of Article 241 is Special Assessments and Extraordinary Fees. Note the title, it is Special Assessments and Extraordinary Fees. Second, note very carefully the procedural requirements before an assessment or extraordinary fee can be levied. Note it very carefully. And the next subsection says, how do you collect the special assessments and extraordinary fees? And note there is an exception except for mandatory activities. Now read it. That portion has been asked 3 times successively in 3 bar examinations. If you look at your textbook, That is ABS-CBN versus Palacol. The ABS-CBN Broadcasting Corporation, second Gabriel versus Palacol. Read it very carefully now. Now, take a look. Because you have to correlate it with some other article. So here, the title is Spatial Assessment and Extraordinary Fees. You read Article 222. Article 222 speaks of attorney's fees, negotiation fees for the settlement of labor disputes. Read it. 222. All right. It must now sink very deep. 222 is not the same as 241, because 241 speaks of a spatial assessment and extraordinary fees. Article 222 speaks of negotiation fees, attorney's fees, and fees for the settlement of a labor dispute. Take a look at the heading. You will note, therefore, that the two articles speak of two different things. Where is the difference? The difference is in Article 241, the special assessment and extraordinary fee is charged against the worker. It's the worker who will pay. Article 222, on the other hand, is going to be charged not against the worker, but against union funds. At this point, let me call your attention. 222 has been interpreted to mean to exclude union service fees. In case you want to know historical background for that, it is your professor, Tony Abad, who was the lawyer who successfully got the theory that it excludes union service fees. You can see how good a lawyer is. I wish I was as good as him. No. I understand his teaching here. Well, anyway, as it sunk, special assessments, extraordinary fees, attorney fees, right? If you compare it further, you will notice that the procedural requirements in Article 241 are very strict. One, the nature of the meeting. Number two, the quorum for the meeting, the vote requirement, and the attestation and reporting requirement. They are not present in Article 222. Clear? They are not present in Article 222. Clear? Which means now there is the next subsection. Except for mandatory activities The way to collect special assessments and extraordinary fees is by way of a check of arrangement in writing by the worker. Read it. In order to collect the special assessment and extraordinary fees, it must be in writing. Correct? Now read Article 113. I am sure you discussed 113 when you were discussing your review on labor standards law. In other words, 113 answers the question, when can there be deduction in wages? In your bar review earlier, I am sure you have digested that article very well. You will note one of the legitimate deductions under Article 113 is check-off. It's there, right? But check-off mentioned in Article 113 is a legitimate deduction, but you have the case of A.L. Amen Transportation Company. For a legitimate deduction by way of a check-off, the law requires that the check-off arrangement may be for union dues. Union dues, D-U-E-S. And if it is a part of the collective bargaining agreement, there is no written authority required on the theory that the union is an agent and the principal are the workers who authorize the union to negotiate. But if there is no collective bargaining agreement, then the written authority of the worker is absolutely necessary. Otherwise, it will be an illegal deduction under Article 113. You compare, that's not the same as Article 241. Why? Because under special assessment and extraordinary fees, it is a mandatory requirement that there must be authority to deduct. Not only authority to deduct, but the recipient, the purpose, the amount must all be duly stated clearly. So, you have compared 222 with 241, and you have compared 241 with 113. Clear? Which brings you now, what is judicial doctrine insofar as Article 241 is concerned? To understand judicial doctrine under Article 241, meaning how did the Supreme Court interpret Article 241, you have to go back and read Article 241 very, very slowly. Read it. Then you will appreciate what the judicial doctrine is. Pay particular attention. Type of meeting, quorum required, voting required, reporting required. Read it very carefully. Just remember one sentence. Strict compliance with all the requirements. The second sentence is no shortcut, no abbreviation. In other words, you have simplified what the law said. You have simplified what the court said. That's the reason why I ask you to read each and every item. Because the Supreme Court said, no shortcuts, no abbreviations allowed. And second, absolute full compliance with all the requirements of the law. Clear? Why? Because it is money. And because it is money, it is a special assessment. Which means the law wants to protect the money of the worker. In Article 222, the law also wants to protect the money of the worker, except that in Article 222, that protection is by way of, say, charge union funds. In 222, charge the worker, but we are protecting him because there is that fence there around, right? It means you cannot have an ordinary meeting for that purpose. And you cannot do it by way of referendum. Clear? But it says except for extra or for mandatory activity. That's something, well, something's wrong in the construction of the sentence. In other words, not germane, but at any rate, the law was not written by a lawyer. So, only lawyers can write, maybe only lawyers can write convoluted sentences. If you remember, just to relax your mind, you have a course in legal forms, right? In other words, how do you transfer the bones from one graveyard to another graveyard? Why? Because the student will always go and look for legal forms and copy it. So he transfers from the textbook to a Kopenban and gives it to the professor. And you are all, I am sure, are aware of the story of how a lawyer described an orange. I'm sure you have read of that story, right? He did not say an orange is a fruit. He said an orange is cylindrical in form. Then he began describing the outer portion of the orange. Then the fruit itself, he ended up with 1.5-page description of what an orange is. If I said that story, it's only to drive home the point. Do not write long, convoluted, ungrammatical, ununderstandable sentences in the bar examination. It will irritate the examiner, especially if he's correcting your test paper at night. It is an ordeal to correct test papers, I assure you that. All right? Now, Article 241 is a very long enumeration, but you can cut it down, right? First, elections of union officers and their compensation. Second, money matters. And thirdly, how do you govern a union? So, election. One man, one vote. Direct vote, no delegated voting authority. Second, major policy issues, the general rule and the exception to the general rule. Money coming in, money going out must be fully explained. So, we'll go item by item. Using a teaching outline is it's not a good way of doing a bar review, but I have no choice. Okay, here. The Constitution and bylaws of a labor union is the governing document that governs the relationship between the union as an institution and the members. And secondly, it is also a measure that determines the legitimacy of an act by a union. It is a contract between the union and its workers. That is what a constitution and bylaw is all about. What is the nature of the relationship between a union and its members? In one word, it is a fiduciary. It is a trust relationship. Why? Because the union as an institution, the worker as an individual, the worker looks upon the union with a high degree of dependency. And because there is that relationship, the union can abuse its own members. Now, the right of a union to promulgate rules for admission and retention of union membership is recognized by law in Article 249, in like manner that it is also regulated by Article 277C insofar as qualification is concerned. Second, the right of a union to discipline its members is a recognized right, subject only to the limitation that when the union disciplines its members, there must be compliance with substantive and procedural due process. Election of officers, direct, one man, one vote, whether it is a national union or a local union. The voters list need not be submitted to the Department of Labor and Employment. No, it is not a requirement of the law. Now, major policy matters, you must be able to distinguish the general rule. Workers must participate, but there are certain exceptions provided for. It's memory work. Union funds, it includes the right to examine during office hours. I call your attention to special assessments. Do you have any questions on Article 241? More specifically, the relationship between Article 241 and 222, and the relationship of Article 241 with 113 of the Labor Code. Do you have any questions? Take a look at your notes. If there's any area that you wish to be further explained, I'll try to do so. Do you have class in the afternoon? You mean the whole day you are reviewing? Alright, take a look at your notes. If there's anything you want to further explain, Article 241, if there is any one area you cannot gamble, it is Article 241. But you cannot gamble not knowing special assessments and extraordinary fees. As I said, it was asked in 3 successive bar examinations. For one reason, I don't know. And you cannot guess. Because if you guess, you're going to get a pat zero for the answer. All right, any questions? Take a look. I'm asking you to take a look at 241. Think of it like it's an insurance contract. It's a contract opere dei fide. It must be explained in full and in good faith. It is not a contract of adhesion. You have a right to demand clarification. It's a contract of remi fide. It is not a contract of adhesion. Lest I be misunderstood, I don't speak Latin. Although if you want to, there's a book being sold, Latin Phrases for Lawyers. All right, it's clear. All right. What do you mean by union affiliation? Union affiliation by judicial doctrine. Oh, before I forget it, read Article 241 on procedural rights, how to enforce a violation, and pay particular attention to the meaning of the word may and who are affected by the violation. Read it now. It's the last paragraph. Now, may I ask you to read Article 226? All right. I suppose somebody must be in charge here. Why don't we try to get a pencil pen and I will diagram some things in blackboards. No, it's not today. So, for the next time, there's an old Chinese proverb. A picture is worth 1,000 words. So if I draw it in the blackboard, maybe correlating one article with another becomes a lot easier. So now, reading Article 241, last paragraph says, any violation affecting one worker or group of workers can be the subject of a lawsuit, but there is a requirement of exhausting administrative remedies first. It's a rule of administrative law that if you want to invoke your right, you must first exhaust administrative remedies within the organization. It is called the exhaustion of administrative remedies in administrative law. Clear? Now, reading Article 226 will introduce you to two things. First, there is an identification of a government office, the Bureau of Labor Relations. And while Article 241 does not mention the Bureau of Labor Relations, the Bureau of Labor Relations is the government office that will administer 241 there. But reading 226 will introduce you to two Latin phrases, inter, intra, union. One is quarrel within, two is quarrel without. Clear? What is referred to in Article 241 is quarrel within. The quarrel is between the union and its members. But that is also referred in Article 226 because it says inter, intra. Inter, intra, there's a distinction. Inter, amongst ourselves. Intramural. That's what it is, right? But you will note one thing. Article 226 says original and exclusive jurisdiction, which means a union member or a group of union members or non-members for that matter, can invoke Article 241 or Article 226. It makes no difference. They are the same. Clear? Clear? So you can forget the percentage. If it affects only one, that one is the complainant. If it affects more than one, all of them. Clear? The percentage requirement is not mandatory. Clear? All right. Union affiliation and union disaffiliation. The principal judicial rule says the right of a union to affiliate and the right of a union to disaffiliate are integral parts of the right of self-organization. I repeat, the right of a union to affiliate and the right of a union to disaffiliate are integral parts of the right of self-organization. Second judicial doctrine says there is nothing unusual, nothing extraordinary. It is a fact of life that one can affiliate today, divorce tomorrow, and remarry the next day, if that's what you want to do. If you have any doubt about it, just read the newspapers. Candidate A today is for B, tomorrow is for C, the next day, depending on how the weather blew, he is nowhere else. That's the same, because I am quoting a judicial decision. There's nothing unusual. It is a fact of life. Now, but the third rule says, if the contract of affiliation provides for a procedure for disaffiliation, and the procedure is not violative of law, the procedure must be complied with. By that, it means the right to affiliate, the right to disaffiliate is preserved as part of the right of self-organization. So, why does a union affiliate? A union affiliates for the purpose of strengthening its bargaining power. Is it similar to marriage? I do not know. Although some faculty members believe that affiliating is the same as getting married. It's the same as getting married. Well, I just remembered what I read in the newspaper in the office of the dean. Even if we separated, the lady said, I still believe in the institution of marriage. Although somebody said, it's nothing but a piece of paper, whether that's true or not. I do not intend to pollute your mind. After all, your civil law tells you marriage is an institution, the preservation of which society is deeply interested. And I am sure that when you discussed your labor standards review, you remember very well that the trust of the protection on women, the first trust is protecting the institution of marriage. Second, protecting the institution of pregnancy. And thirdly, protecting sexual harassment. And lastly, your favorite article, women in special workplaces under certain conditions. Under certain conditions are considered employees for purposes of labor and social legislation. Well, that one I shall never forget, because I remember it was highly controversial in our school, because they discovered that some members of the faculty were frequenting a place of entertainment somewhere in Quezon Avenue after the bridge. I think the name is Picasso's or whatever. I was not there, so I am not. But secondly, the cuts to it caught a lot in a bar examination, because the question described the worker, but there was one thing missing in the question. And a lot of students fell into the trap because it said, for such period of time under the supervision as determined by the Secretary of Labor. That one was absent in the statement of the problem, and everybody, hook, line, and sinker, swallowed it. To be considered under that special, that's Article 138. Say, 1, a lady; 2, in places of entertainment, with or without compensation, but whose period of time is supervised under the rules and regulation of the Secretary of Labor. Anyway, I just mentioned that. All right. So anyway, what is the purpose? It is to strengthen the bargaining power of the union, right? Thirdly, legal personality, and this is where the question is. A union that affiliates with a national union, the legal personality of the two unions are separate and distinct. In other words, the legal personality of the national union and the legal personality of the affiliate are preserved by law. Because the law preserves the separate legal personalities, the two are separate consensual bodies that can enter into a contract. But whatever contract is entered into, the principal is the local union. The national union is merely an agent, which means, therefore, the national union did not create the local union. Which brings you to the point. If it is a preserved separate personality, a collective bargaining agreement is owned not by the national union, but it is owned by the local union, even if the two are signatories. Now, I call your attention to the amendment of the law that supervisors and rank and file unions can now affiliate with the same national union, and therefore Article 245 is not violated. And the ruling in the three cases have long been gone. Now, do you have any question on this affiliation and affiliation? As long as you remember the cardinal rules, it is to strengthen, but their personalities are separate and distinct. They are not merged. Clear. Now, union security provisions. Union security provisions, you will note, are valid institutions in the Philippines because under Article 248, it says, nothing in this code will prohibit a union and an employer from negotiating that membership in the union is a condition for hiring, a condition for continuing employment, and if it is lost, is a ground to terminate. Union security provisions, therefore, regardless of whatever textbook you are reading, there are only three major categories. The rest are merely variations. Closure, unionship, maintenance of membership. And they all revolve under one theory. The theory is we have to have union security provisions in order to implement the policy of the law in Article 211, a strong and united labor movement. So what are they? Closure, unionship, maintenance of membership. Regardless of what it is, your focus should be on three areas, because the three areas indicate the differences among the three. The first area is the employer's access to the labor market, meaning access to the worker at the time of hiring. Your second area of concern, after hiring has been done, it is a condition for continuing employment. And your third area of concern is, if union membership is lost, what is the effect on the employment relationship? But covered in all three is the blanket, like Linus and his blanket, is compliance with substantive and procedural due process. So you can see the scheme of the mechanics of the law. Protection, but protect the worker as well. Clear? If it is a closed job, and a closed job means at the time of hiring, the worker must be a member of the union and must continue union membership as a condition for continuing employment. And if union membership is lost, it is a ground to terminate employment relationship. Clear? If it is a union shop arrangement, the worker need not be a member of the union at the time of hiring, but must join the union at a reasonable time thereafter, specified in the contract, must maintain that union membership as a basis for continuing employment, and if it is lost, it is a ground to terminate. Note now that exactly the same insofar as a ground to terminate, but they differ at what time it is effective. Time of hiring, the other one, no. The middle ground is what is known as maintenance of membership. Maintenance of membership means at the time of hiring, the worker may or may not be a member of the union. It is immaterial. But the middle part as a basis for continuing employment. If the worker was a member of the union or joined the union thereafter, membership in the union must be maintained as a basis for continuing employment, otherwise there is a ground to terminate. But in all cases, there is a need for a precision on how the contract is drafted. And secondly, in all cases, when it is implemented, there is a requirement that before the worker can be terminated from employment, there must be compliance with substantive and procedural due process. Meaning, even if the union assures the employer that we will hold you, the employer, free from any and all liabilities, it is not a ground for the employer to dispense with procedural and substantive due process. And it is a right of the employer to demand, even if the union should threaten the employer or the union would leave. The last form of security of a union is financial security, and that is union dues, and secondly is the agency fee in collective bargaining. Just read Article 269 to 70 insofar as international activities of the unions are concerned. Do you have any questions? What time is your afternoon review? 1 o'clock. So I suppose I must keep quiet. You all have to go and eat anyway. I can see the relief. All right, I will not go beyond 11:30 next. All right. I've done and covered some ground.